Hello everybody, dear friends and supporters of the Käthe Hamburger Center for Advanced Study in the Humanities, Law as Culture. Welcome to Pamela and to our talk of tonight. Her lecture is entitled Mothers on the Move, Social and Legal Anthropological Perspectives, and will be held exceptionally in the conference room at the Rohmühle. The presentation conveys an impression how migration engenders the contact and potential conflict of legal cultural belief systems and attitudes. It especially highlights the everyday normative force of the law by illustrating how migrants' identities and courses of action are configured by encountering an alien legal practice. This was a way to find an understanding of what you should say, but you will say what you want to say and not what you ought to say. Please allow me to say some words about the lady's background. So we should take and must take hours, but I have to reduce a lot. Social anthropologist, that's your professional background, you hold an endowed chair as Broom Professor of Social Demography and Anthropology at the Department for Sociology and Anthropology at Carleton College in Northfield, Minnesota. One should say, perhaps, that why is European academia unable to give name to chairs? Why? In order to express recognition. Why? Because in the end it doesn't cost so much money to do that. It's just a name.
It saves money.
It saves money.
Because the donor gives money for the chair.
Yes, this also. So this is all
Takes the donor, this is the point.
No,
but
but it's really a question, and it's a problem of our academic society as in Europe that recognition is something we can't deal with. And I always have kind of envy for the American universities who are able to do it in a much, I think, more intelligent way than we in Europe. So you are director of the African and African American Studies program since August 2013, a long time. She is also fellow at the Käthe Hamburger Center for Advanced Study in the Humanities, Law as Culture, as you have remarked earlier. You graduated from Indiana University, Bloomington, and we were just talking about Bloomington, what a wonderful university it is, but it's some time ago, if I remember well, with a Bachelor of Arts in Social Anthropology before serving in Cameroon as a Peace Corps volunteer from 1980 to 1981. This is not possible, it's a wrong indication, it must have been much later. She returned to Cameroon several times to conduct long-term ethnographic research, and this is also background of the talk you will give today. Attracting numerous research grants. I don't know what exactly Sigma is, but Fulbright I know because I have been a Fulbright professor myself. When a Grant Foundation and the National Science Foundation I know. You obtained both a Master of Arts, a PhD in Anthropology from the Johns Hopkins University in Baltimore. Following several academic appointments at the University of Hanover, the University of Minnesota, Minneapolis, and Hamlin University, she moved to Carleton College in 1993, where she holds this endowed aforementioned chair. Currently director of the African and American Studies program, she was an Andrew Mellon Fellow in Anthropological Demography at the University of Pennsylvania from 2000 to 2001, headed a project on social networks and reproductive health in Cameroon funded by the National Science Foundation from 1997 to 2002, and conducted research at the Max Planck Institute for Social Anthropology in Halle, as well as at the Institute for Social and Cultural Anthropology at the Freie Universität Berlin. Funded by the Werner Green Foundation for Anthropological Research, she spent 2010 to 2011 conducting ethnographic and interview-based research among African migrants in Berlin. And this is the background of your talk, the empirical background. Professor Feldman Savelsberg's research interests lie, so as you might have guessed, in African studies, gender studies, that is important for you, medical anthropology, but also, and this has not been so much emphasized before, with a political perspective. Building on extensive research in the Cameroonian grassfields region and the capital, Yaoundé, she is currently investigating the mutual constitution of reproductive practices and legal, social, and affective belonging among African immigrants in Europe, with a particular focus on Cameroonian women in Germany. Since August 2013, once again, so I don't have to repeat that, we know that she's here. Okay. So, but the abstract, in her abstract, she says, based upon ethnographic research with Cameroonian migrant mothers in Berlin and ideas about legal consciousness, this presentation focuses on how everyday experiences and understandings of law shape the ways migrant mothers find partners, get married, bear children, and raise them. It shows how African migrants tell each other stories about their encounters with German regulations and the teachers, physicians, and public officials who enforce them. The resulting narratives form the basis of collectively held ideas about getting along with the law in a new place. They become part of the creation and transmission of culture and normativity. But how the concept of legal consciousness might help to understand the true meaning of the way migrant mothers become storytellers of their life and their processes of adaptation to somehow culturally different settings. Ideal and real models of family life. If family, in presence of Professor Depper, one has to insist on that, is at all a common ground formula of understanding in this context. How strange is the law of the other, and last but not least, who is the other in this encounter? And how communication about the law is possible in intercultural exchange. A very general question, but with concrete consequences. Or do we have to understand law as a kind of medium, a language of making the other more understandable? This would be a completely different function of the law, or a tool, or a way just to understand the law. That itself, it is not only a hindrance to communication, but perhaps a means of communication. And finally, the concept of legal consciousness. So some of us might have some problems with this, but might also be fascinated by the concept. How does it relate to the legal cultures implicit? The legal pluralism, is it part of the conscience collective in the Durkheimian sense, as expressing the commonality of beliefs? In German we would say Rechtsglaube, Rechtsmythen, and also of sentiments. That means something that is completely thrown out of the debate in the sociology of law and in the theory of law, that is the emotional side and perhaps even basis of the law. So I'm very sure more questions might arise when listening to you, and therefore the floor is finally yours. Thank you very much for coming, and I'm really very curious to know about it, because she didn't tell anything before. Nothing, just the abstract. So I'm really curious to see what you will tell us. Thank you very much for coming.
Thank you, Werner. Thank you very much, both for hosting me and your kind introduction, your creative intellectual leadership, and these wonderful questions to pose. So keep Werner's questions in mind when I talk. I also want to thank I'm Nina Detloff, and the Mitarbeiter, the student workers of the Kolleg, my fellow fellows, all of whom have so kindly given up such a beautiful evening to venture into the life worlds of African immigrant families. This evening, I'll talk with you about African family migration to Europe and how it is shaped by law. More specifically, I'm concerned with the many ways that African migrants' everyday experiences with the law and the understandings they form about the law affect family formation. In turn, I'm curious about how individual encounters in the course of creating and raising families get crystallized into new legal cultural beliefs and attitudes. These concerns lead me to a series of very practical questions at the meeting place of African experiences and European family law. First, what counts as family? Second, what counts as marriage? And third, what is the proper way to raise a child? I'm a social anthropologist, and like most anthropologists, I approach both my analytic and pragmatic questions through a specific case, that of the Cameroonian migrant mothers in Berlin. My long engagement with issues of family life, shifting ethnic identities, and migration within Cameroon allows me to contextualize my Berlin research in terms of culture and process. As an ethnographer, I also look in the first place at the ways interlocutors talk about family, migration, and the law, and how they think about them, tell stories about them, and thus circulate ideas about them. I pay attention to the texture of everyday life and work mostly inductively. But nonetheless, and again, like most anthropologists, I pose my questions and seek answers with analytic concepts in mind. I'm not completely a barefoot empiricist. Tonight, I frame my presentation in theoretical ideas regarding legal consciousness. Before I proceed, please let me provide some background on legal consciousness as a concept, and some context on Cameroon, on Cameroonians in Germany, and on my research setting. So first I turn to legal consciousness. The analytic concept of legal consciousness refers to understandings and meanings of law that circulate in social relations. The concept of legal consciousness was developed among socio-legal scholars such as Susan Silby, Patricia Ewek, and Sally Mary to explain how law maintains its institutional power despite its variable, unequal implementation. The founding thinkers of legal consciousness propose that because legality suffuses everyday life, forms of legal authority become routinized and habituated, and thus enduring. This is a view of law from below, approaching law as culture. In legal consciousness scholarship, the ways people understand and make sense of the law emerge from everyday experience and social interaction in the same manner as do other aspects of culture. When people engage with the law through the routines of everyday living, legal orientations towards the world become habituated, reminding us of Mauss and later Bourdieu's writings about habitus and the embodiment of culture. When people tell stories about their interaction with legal rules and institutions, they circulate meanings that become patterned and stabilized into collectively shared orientations. Because people circulate stories about the law within socially structured networks, generally among those who share a roughly common position in society, legal consciousness reflects and often reinforces the structuring of social life. How it does so varies from place to place and over time. In their exemplary study of legal consciousness in the United States, Ewek and Silby identify three common patterns that they call before the law, with the law, and against the law. Before the law sees law as remote, an objective realm of disinterested action operating by fixed rules, removed from engagement with personal lives. With the law means playing with the rules of the game. With cumulative experiences, people get better and better at using the law. In addition, those with greater cognitive, informational, and economic resources are best equipped to play strategically with legal rules and promote their interests. against the law sees law as impersonal, repressive, and indifferent. In this view, law is a capricious product of power to which ordinary people respond with ruses, tricks, and subterfuges. Among Cameroonian migrants to Germany, legal consciousness has a new emergent field, too new, I would say, to identify such clear patterns. The legal consciousness of Cameroonian migrants is further complicated by the multiple legal systems that serve as reference points for Cameroonian family formation. Even before leaving their country, Cameroonians regularly and simultaneously engage with many different types of law. Each ethnic group in Cameroon has its own set of legal norms, processes of dispute resolution, and regulation of daily life. From its complex history under German, French, and British rule, Cameroonian state law incorporates both statutory and common law elements. Due to significant internal migration and the coexistence of multiple state and customary law systems, Cameroonians are familiar with navigating in settings of marked legal pluralism. Migration to Germany engenders contact with yet another legal cultural belief system, and with a society and set of social actors, Germans, the others, who are unaccustomed to legal pluralism. Cameroonian migrants interact with German legal institutions for momentous occasions, such as obtaining visas, getting a marriage license, or changing their citizenship. The imprint of law makes itself felt in more subtle realms of socially reproductive practices, such as choosing lovers or disciplining children. Sharing stories of everyday joys and sorrows, including encounters with German officials, is an important element of Cameroonian migrants' sociality. Migrants exchange family settings, exchange stories in family settings and at community meetings within the same networks along which migrants provide care and forge belonging. Recently arrived migrants learn from those who are more settled and experienced within the German system. The stories Cameroonians tell each other about everyday interactions with neighbors, with teachers, physicians, and public officials crystallize into collectively held ideas about getting along with and in spite of the law in a new place. This is the essence of legal consciousness as a process of meaning-making. It is here that culture, including legal cultures, are formed, contested, and interwoven. Cameroon is often called Africa in miniature. Nestled between West and Central Africa, it is both geographically and culturally diverse. Once a German colony during World War I, Cameroon was divided between Britain and France in a League of Nations mandate, resulting in a legacy of two systems of state law, common law and statutory law, as I mentioned before. And Cameroon gained independence in 1960, became a bilingual federal republic in 1961. Francophones comprise about 80% and Anglophones about 20% of the Cameroonian population, which is currently around 20 million. My research of the past 30 years has focused on groups living on the frontier between English and French-speaking Cameroon, right in here. This is the English-speaking part, and all of this is the French-speaking part. That's where I worked. The Francophone Bamileke and culturally similar Anglophones of the Northwest region. Since the colonial era, the mountainous plateau region of the grass fields, which is this area taken together, has served as a labor reserve area. Women as well as men migrate to seek wage employment, to pursue education, to get married, and to settle in urban centers. Both groups have a long history of political marginalization within Cameroon. The Bamileke, nearly 30% of the Cameroonian population, were leading figures in an armed conflict against the colonial and post-colonial state carried out from the mid-50s to the mid-1970s. Since then, state propaganda doubting Bamileke trustworthiness, combined with Bamileke predominance among rural to urban migrants, has made the Bamileke objects of resentment among other Cameroonians. This resentment even has a name, the Bamileke problem. Don't believe this. the Bamileke problem. At the turn to the 20th century, with the introduction of multi-party elections, the ethnicization of politics, this resentment increasingly found its expression through law, including discrimination in voting rights, in civil service employment, and in university admission. Anglophones, English speakers, have their own Anglophone problem, facing political and linguistic marginalization in a Francophone-dominated country. Anglophone grassfielders share with the Bamileke a similar reputation for entrepreneurial drive and a history of labor migration and domestic diaspora formation. In addition, Cameroon's major opposition party was launched in the English-speaking part of the Grassfields region, in Bamenda, which you saw on the map in the slide before. Thus, in many ways, Bamileke and Anglophone grassfielders lived lives characterized by strangerhood within their own country. Increasingly, this motivates them to seek their fortunes abroad. Cameroonian migration to Germany is fueled by young adults' contrasting images of Cameroon in Europe. In these images, Cameroon is a place of great obligations and limited opportunities to fulfill them, particularly for Bamileke and Anglophones seeking higher education. Europe, by contrast, is imagined as a place of opportunity where anyone with the right combination of luck and persistence can earn material success, perhaps a prestigious university degree, and certainly respect and admiration from those back home. Cameroonians also seek better conditions in which to found and rear families. Women's migration decisions reflect African women trying to make choices for future children and for their children's future. With its nearly free university education, Germany has become a popular destination among Cameroonians' emerging middle class. Like many African migrants to Europe, Cameroonians also seek economic opportunity in Germany's strong economy, but immigration law makes labor migration nearly impossible. Thus, family reunification and educational migration are the most frequent, here for Berlin, you see the percentages, most frequent means of legal migration from Cameroon to Germany. Indeed, many Cameroonian migrant mothers arrive as students or come to join a student spouse. These pathways shape the composition of the Cameroonian migrant population in Germany. They are young, of childbearing age, relatively well educated, and disproportionately Bamileke or English speaking. By 2012, over 16,000 Cameroonians were legally registered in Germany, well over 2/5 of whom are women. Berlin itself hosts a sizable Cameroonian immigrant population with nearly 2,000 documented migrants geographically dispersed in this metropolis of 3.5 million people. Undocumented migrants and Cameroonians who have become German citizens add to this number. My broader book project that I'm undertaking here at the Käthe Hamburger Kolleg explores the tension between migration and belonging, focusing particularly upon reproduction, on ways Cameroonian migrant mothers forge connections through bearing and caring for young children. Through their reproductive labor, mothers create ties to kin, to migrant community organizations, and to the states. I traced these processes in 3 locales: a rural Bamileke chiefdom, among Bamileke in Yaoundé, Cameroon's capital city, and in Berlin. I began my long-term participant observation research on reproduction and shifting ethnic boundaries in rural Cameroon in the 1980s. That date was not wrong. And continued with an extensive study of women's social networks in the 1990s and early 2000s, and conducted the research upon which this talk is based in Berlin in 2010 to 2011, with some kind of ongoing contact with some key informants and people who became friends, including one law student. I undertook participant observation in homes, at life cycle events, in daycare centers, social service agencies, and medical clinics throughout Berlin, especially in the neighborhoods of Wedding, Reinickendorf, Friedrichshain, and Lichtenberg. I conducted over 50 in-depth, semi-structured interviews with transnational Cameroonians, including Cameroonian immigrant mothers, plus a few mothers-to-be and couples. Most interviews took place in women's homes. I also interviewed staff in family planning centers, clinics for the uninsured, social service and immigration offices, a training center for migrant youth, a home for asylum seekers, and the African-led community-based organization in which I volunteered, Project Afrika Herz. Trust, or rather mistrust, was a common theme for my interlocutors within their own communities and social circles, as well as for my relation to them as a researcher. To mitigate mistrust, I let my interlocutors choose their own pseudonyms and took few pictures, almost none with recognizable faces, which explains a little bit what pictures you see in the slideshow. Now I turn to my 3 pragmatic questions that I've chosen for tonight to explore Cameroonian mothers' legal consciousness regarding family making in a new land. First, what counts as family? How is family legally bounded for purposes of migration through family reunification? How are African migrants' ideas regarding family and the moral imperatives of care transformed in response to the legal environment of transnational migration? In Cameroon, Bamileke and most other grassfields people define family broadly, reaching well beyond the co-resident household. Lineage affiliation provides important guidelines regarding rights, obligations, and sentiment. Lineages are traced on both the paternal and maternal sides, and members of the same lineage may serve as proxies for each other in customary legal proceedings, including marriage. Caring for children, a most significant function of families, is often distributed among many actors in several households. Sending a child to be raised by older siblings, grandmothers, and aunts and uncles is considered good parenting practice, as it provides the child with new opportunities and experiences. In immigration law, by contrast, family reunification rules work with a more narrow definition of family. Family reunification doctrine declares that specified relatives of a legal migrant should be allowed to join him or her in the new country of residence. Spouses and dependent children count as family. Within the European Union, states set temporal and biological limits on who counts as a dependent child, employing bone density scans, for example in Spain, and DNA tests, as we've heard from France, to determine age and biological relatedness. These rules affect freedom of movement, not only for immigration, but also for longer-term visits. Adult children, siblings, aunts, and uncles do not count as family for immigration purposes. But these are exactly those relations most likely to provide practical and moral support to a new mother and to help care for a young baby. Difficulty getting visas, as well as distance and expense, make fulfilling the strong cultural expectation for female kin to help out following childbirth nearly impossible. My field notes are full of laments that being pregnant and caring for infants in Germany all alone is hard. This loneliness is, of course, partly a consequence of law. Cameroonian migrant mothers share stories with each other that contrast childbearing in Cameroon with childbearing in Germany. Christine, a Bamileke political refugee, contrasts her experience as a teen mother in Yaoundé with bearing her second child after seeking asylum in Germany. By the way, this is an asylum camp in Belzig, which is in Brandenburg, a little bit outside of Berlin. In Cameroon, for example, you are surrounded, you have your family, and here you are alone, alone, alone. In Cameroon, when I had my first son, I still lived at home with my parents. It was my mother who took me to the hospital. I gave birth, she was at the hospital with me, and afterwards, she brought me back to the house. At the house they cooked. It was a party. For a month, there were always lots of people, visitors, like that. Afterwards, I just rested, and they took care of the baby. But here, alone. Through sharing such stories, migrant women create a common orientation and vocabulary that organizes their experiences into 2 ideal-typical spheres of a highly social and supportive Cameroon and an overwhelmingly complex Germany where mothers are all alone. framing this in terms of legal consciousness, women use these contrasting images to make sense of the consequences of law. Lily links the absence of family members to the difficulties of navigating a new legal bureaucracy. Here in Europe, you have to do it all yourself. It's hard being a mother here. You need to fight to get all your papers in order. You need to find out all the information yourself. Because immigration law defines family narrowly, essential family ties are reduced to material exchange. When So'onyut's husband traveled to Cameroon, her relatives supplied him with zimzim pods to bring back to So'onyut. They always give him zimzim pods because for all the bamileke, that must be in the house. When you are sleeping and have bad dreams, you place it under your pillow. Now when her baby is disturbing, as she put it, So'onyut chews the pod's dried sweet seeds and sprays the spit onto his fontanelle or belly to calm him. These and other small packages sent back and forth for traveling acquaintances maintain family ties and identity in the face of legal restrictions to migration. The challenges of maintaining relationships with extended kin contribute to changing ideas about family among Cameroonian migrants. I noticed Cameroonian mothers' aspirations towards companionate marriage and their increasing focus on the nuclear family. This transformation is rife with ambiguity, as illustrated in the following encounter with Lily. A rare moment of quiet permitted us time to sit on her sofa together, looking at her family photo album of wedding portraits and baby snapshots. On this gray afternoon, just before spring returned to Berlin, gazing at Lily's photo album brought our conversation back to family ties. Lily came from a large Bamileke family, most of whose members migrated from the Cameroonian port city of Douala to the outskirts of Paris when Lily was in her late adolescence. She moved to Berlin only after meeting her husband, who was both a university student in Germany and a deacon in his Pentecostal church. Their church underscored an ideational transformation, emphasizing nuclear family ties already underway among most Cameroonian migrants to Berlin. How might this transformation in family norms reflect the effect of immigration law? Lily says, sometimes one confuses things a little, frequently putting family in front of one's proper family. That's to say, one's husband and one's children. Sometimes one pays too much attention to one's mother or father before looking after one's husband and kids, and vice versa. The husband will look after his mother too much in relation to his wife and children. And that's a little bit the problem one has among Africans. They don't manage to make this distinction, and that's not good. But nonetheless, I think that family is very important, especially when one's relations with them are very close. When you have good relations, as is the case in my family, I have great relations with my mother, my sisters, my brothers. And just as a side note, I've translated all the French quotes into English, so this is my translation. If it's a little awkward in places, you know who to blame. Here, Lily expresses the lived tension between the needs of the nuclear family and migrant spouses' emotional and material obligations towards their families of origin and extended kin. The difficulties of travel engendered by legal definitions of family in immigration law may contribute to troubled transformations in how Cameroonians set boundaries of what constitutes, as Lily calls it, the proper family. The next question, what counts as marriage? Anthropologists have long written about ways that marriage creates relationships between families. It's the core of some of Levi-Strauss's work. Among Bamileke and other grassfields people in Cameroon, marriage sets off a cascade of exchanges that tie kin together, legally, structurally, and through sentiment. Once a couple is married, ever wider circles of kin take an interest in their reproductive lives, expecting the couple to make people that extend the network and reach of the family. How do the realities of migrant life affect the ways African migrants find partners and perform weddings? Cameroonians perform 3 types of weddings: traditional rites, civil marriage, and church weddings. Due to personal choice, family expectations, and available resources, some couples perform only one type of wedding, while others may perform all three. Each of these types of weddings are legally recognized in Cameroon, including both monogamous and polygynous versions of civil marriage. Only monogamous civil marriage is legally recognized in Germany, affecting issues such as immigration, social welfare, and I believe child custody. Maria and Paul, over a period of 5 years, performed all three wedding ceremonies, albeit with a twist of adaptation to the financial and legal constraints of migrancy. In the customary law of Maria and Paul's hometown in the English-speaking Grassfields region, a marriage is considered legally binding only after the groom's family has given a previously negotiated combination of money, material, and labor to the bride's family. Maria explained her sense of the proper order of things in which traditional rites, forging material and emotional exchange among a wider set of actors, take primacy over civil and church weddings and must happen first. However, Maria and Paul's financial situation as students and the visa complications involved in traveling across borders kept both of them from traveling to Cameroon, so they innovated, performing a marriage by proxy, followed by a civil wedding in Germany. Only several years later, when both Maria and Paul were securely employed in Germany, did they travel to Cameroon to complete the traditional rites in person and to stage a white wedding. We got married legally here in Germany, and then we went back to Cameroon, and then we did the wedding there. But with us, before the legal marriage, we must do the traditional rite, the necessities. So my husband did that, and that could be arranged without us. We performed the traditional rites in Cameroon in our absence. I had to choose one of my sisters to stand on my behalf, to represent me as the bride, and give my word that I agree. In marriage by proxy, the public exchange of bride wealth vows of solidarity, bride wealth, and vows of solidarity between family members and blessings for the newlyweds legalized the union regardless of the presence of the bride or groom. Close family members, for example, Maria's sister, serve as proxies for stating vows, pouring libations, that's what's happening here, so pouring palm wine, and being anointed with palm oil and camwood powder. Like all rites of passage, weddings are moments when transformations of social status are made publicly visible and social relationships are documented. In highly mobile populations, a video of the marriage by proxy ceremony serves as proof of the validity of the legal relationship, with its attendant implications for rights and responsibility. Couples play and replay wedding videos in their living rooms, reliving in the presence of friends the wedding's protocol, the ritual performance of a legal act. Such videos have even been used as court evidence, successfully documenting marriage in asylum cases. I'd like to address one last issue with regard to marital practices of Cameroonian migrants and what counts as marriage. Do African migrants respond to the constraints of Fortress Europe by orienting their marital and reproductive lives toward European nationals, or toward fellow Africans from their own or neighboring countries? How does the coexistence of different norms regarding obligations to family affect the durability of legal unions? You may have heard of a recent law on sham marriages, submitting binational couples to heightened surveillance. Stories abound of African migrants without visas seeking to regularize their immigration status through marrying German citizens. These are not just Stammtisch tales. In her detailed demographic ethnography, Annette Fleischer found that recent Cameroonian immigrants orient their marital and reproductive lives in Germany more towards Germans than towards their compatriots, in response to immigration rules that restrict legal immigration for less skilled workers. My research indicates, first, that binational marriages serve more purposes than regularizing immigration, And second, that an orientation towards binational marriage may be relatively short-lived. Longer-term Cameroonian residents of Germany, as well as those who arrive and stay legally, tend to seek out relationships with fellow Cameroonians. Indeed, nearly all migrant mothers I came to know were in relationships with other Cameroonians. Quite a few, though, or more commonly their current partners, I think it's more common among men, had previously been in relations with ethnic Germans, with consequences for legal status. So'Nyu, for example, joined Nya, her boyfriend and father of her baby, in Germany after Nya had regularized his status by marrying a German woman. Because Nya wanted to remain married to his German wife until he had attained a more permanent residency status, he encouraged So'Nyu to avoid contact with other people and to mistrust other Cameroonians' advice. My husband told me not to ask, because when you go and ask, people will tell you one idea, because he suffered the same thing when he came. At that time, he was with a German woman, so I was just indoors. It was not easy. This lets you know that even though Cameroonians share stories about how to get along with the law, all the stories are not helpful, or they don't judge all stories to be equally helpful. Many women had strong opinions about binational relationships. The Cameroonian migrant mothers I spoke with characterized binational marriages between Cameroons and Germans as fraught with tension. Contemporary German ideas of relative independence clash with Cameroonian norms regarding family solidarity, particularly sending remittances to Cameroonian kin. Many of these women characterize low German birth rates and husbands who want marriage without children as evidence that Germans, in quotes, do not like children. As Frau Schwartz told me, I really had to convince him, really, because he did not really want it. He was not really into it. It brought us a lot of problems, you know. Most of our problems were about this child thing. Binational couples are not embedded in a network of enduring multiplex relationships that, as the legal anthropologist Max Gluckman proposed, would encourage them to resolve marital disputes. Cameroonian migrant mothers circulate stories about the legal and social implications of binational marriage and why many are short-lived. They underscore differing norms regarding family boundaries, obligations, and autonomy. To use the vocabulary of legal consciousness, their stories crystallize into shared, future-oriented ideas about working with the law and, as So'Nyu's testimony points out, also working to avoid the law. Now I come to my third and last main question. What is the proper way to raise a child? How do African parents respond to the bureaucratic regulation of infant care, including male circumcision? How do they maintain culturally significant forms of respect while dealing with contrasting host country norms regarding discipline, all in the shadow of youth protection services? For Cameroonian parents living in Berlin, the proper way to raise a child is to root it with a feeling of belonging to a Cameroonian community. Belonging, they say, is the basis for resilience when facing the hardships of migrant life. Mothers face a difficult balancing act between forging Cameroonian belonging and fostering adaptation to the German environment. Bodily practices, such as the circumcision of young boys, mark belonging. But in Germany, circumcision is anything but self-understood. As Jukal told me, it's not a tradition, it's not a culture here in Germany. They don't do circumcision. Jukal had a difficult time articulating just what made circumcision part of being Cameroonian or Bamileke. She was nonetheless adamant that circumcision was one part of raising her son as a Cameroonian. I don't just know. It's just like it's something in the brain. Every male in Cameroon is circumcised. So I don't know whether, I just know it's something. Although here they say it might be there is dirt inside. People don't know how to clean it well, so it's good you cut it in order to be clean. But I just know that every man should be circumcised. Not should, but where I come from, they do that. Even if you are undressing in like a beach or whatsoever, people will be looking. In 2012, when Jukal and I discussed the recent circumcision of her baby, insurance did not cover circumcisions that were considered for cultural reasons. Jukal received addresses for pediatric surgeons from her pediatrician. So many addresses. So I just called. It's business. You pay them €200 for their services. Health insurance companies, rather than physicians or courts, served as control agents for conflicting norms. In 2012, as we all know, a local court in Cologne ruled that circumcision constitutes bodily harm, Körperverletzung, followed by an outcry from Turkish and Jewish organizations in Germany, as well as major German churches. Since then, a new law has sought to clarify the legal status of male circumcision. But because Cameroonian circumcision practices are based on custom rather than on the doctrine of a world religion, their situation remains uncertain. In conversing with mothers of preschoolers and older children, I frequently heard variations on the phrase, "I have a German child." Parents observed their children's German socialization with a mixture of pride, exasperation, and fear. Their little ones were somehow making it culturally in Berlin, gaining a cultural fluency that would ease their future life course in Germany or elsewhere in Europe. But parents were horrified at what they saw as German children's serious lack of respect towards elders. At the Kita, or daycare center, children learn to be relaxed about generational boundaries, addressing adult caregivers by their first names, asking back, and even questioning authority. Parents feared that lack of respect could later translate into unruly behavior. Parents worried that their children might become unmotivated or unwilling to take advantage of the opportunities available in Europe. Cameroonian parents work to keep their children Cameroonian through a variety of strategies, from naming practices to bilingualism to folkloric participation in Cameroonian festivals. Most importantly, they teach them respect through strict discipline. B described her reaction to her daughter's misbehavior. You hold her hands down and you very seriously talk to her, not like, "Nein, man darf das nicht machen," like Germans do. When it comes to respect, I'm very strict on her with that because I realize it's something else here. I interjected, "Do you worry about her being more like German children?" And B responded, "Yeah, I worry about that so much. Yeah, so much. That's what I think makes me be a bit harder on her. Because of those worries. I wouldn't be that very strict if I was in Cameroon because I knew she would grow up adopting to those values there. But I try to be a bit harder because I know she only has me to learn from. But in Cameroon, she would have me and the society." When it comes to enforcing discipline, mothers feel handicapped by prevailing German ideas about children's rights enforced by authorities such as teachers and child protection services. Corporal punishment is legal and common in Cameroon, but sanctioned in Germany. Jukal viewed her new legal environment with consternation. You can't do anything to the child because they know they have their rights. As Iris explains, parents feel little privacy about the child-rearing strategies they employ in their homes. They experience classmates and teachers' interest in their lives as suspicious intrusions. Even with their friends, when they are playing, "What did you do yesterday?" the children are talking. Before you know, the teachers know what is happening in your house, how your parents are treating you in the house. Parents thus worry about being reported to the Jugendamt, about facing possible sanctions for raising their children the best way they know how. The legal consciousness approach emphasizes the development of collective orientations to the law through the circulation of exemplary personal stories. Iris recounted that Cameroonians circulated information and personal accounts about children invoking the right not to be punished. We always say, in the African community that these children are born with rights. They are born and they just know their rights. Parents worry together about the long-term consequences of their inability to enforce discipline. Brenda, reflecting on her encounters with mothers of older children, stated, "My problem is here that the way I was brought up, if I were not brought up like that, I would not be what I am today. So I want to make sure my child grows up in that way to be something tomorrow." Through the retelling of cautionary tales, these mothers' individual experiences coalesce into a shared Cameroonian discourse of drastically limited parental rights to discipline their children. In this case, they do not avoid or work against the law, but instead are frustrated by what they view as its intrusive power. Daniel Kohlhagen, working with irregular male migrants from a different Cameroonian ethnic group, suggests that Cameroonian migrants in Berlin make a clear distinction between their law, meaning German law, and our law, meaning Cameroonian law. Their law is the law of whites, relevant to and favoring Germans and other white Europeans. Our law is the law of Cameroonian immigrants, an amalgamation of adapted customary law, for example, dispute resolution by elders, and received wisdom about the ways to avoid the mysterious and working against them detrimental and harsh, those in quotations, German law. Newcomers learn from old hands how to play tricks on the law, for example, by sharing work permits or insurance cards, and how to use the law to regularize their immigration status. Most of the migrant mothers I worked with had lived in Berlin for several years, arriving and staying legally. Instead of distinguishing between their law and our law, they in turn work with the law, avoid the law, and are frustrated by the law. Above all, Cameroonian women are still seeking how to balance normative expectations from home with a new legal environment abroad. They counsel each other on ways to make their marriages work, how to get help, to substitute for absent kin, and how to instill Cameroonian values in their children despite foreign cultural influences. This evening we have seen that law sets the parameters of migrant women's everyday experience of making families, the restricted pool from which to choose partners, the occasional instrumentalization of romantic relationships, the recognition of only certain types of marriage and only certain types of kin as family, the resulting absence of supportive kin at crucial life cycle moments, the fear that without discipline one's children will go astray, and the fear that an intrusive state apparatus will prevent parents' attempts to enforce Cameroonian norms regarding respect. Even when they do not mention the law, or a particular law, explicitly, women's life narratives comment upon the way that law affects family making. The cautionary tales they circulate in the course of everyday socializing develop into shared orientations about getting along with the law in a new place. Through founding families and rearing children, women encounter and develop understandings of the law. This migrant legal consciousness is new, emergent, in flux. We note migrant mothers developing strategies that shape their marital and reproductive lives, their normative obligations to kin, and their changing child-rearing practices. Thank you very much.